let's start with this discussion, with a panel discussion. Before I give the word to anyone, I would like to introduce our panelists. First, to the furthest left is Petra Hertzfeldt-Olsson, who's Associate Professor in International Labour Law in Uppsala University. Next to her is Sofia Rosmar, who's a legal counselor here at TCO. And beside Sofia is Professor Ulf Bernis, who's a professor in European law at Stockholm University. And here next to me, Professor Mark Friedland, who is also a professor, but in Oxford. Yeah. So, well, the picture that has been drawn today by the speakers here is that of a tension, to say the least, a conflict between internal market law and labour law, both European labour law and labour law in the member states. Of course, this book includes some other perspectives, as I think it was Jeremiah who told about this Dorota Lejkiewicz, excuse my pronunciation, who argues that there is, in fact, a social dimension inherent in the internal market law itself. So in her view, the problem is that the social benefits of cross-border wage competition are not enough recognized by the EU Court of Justice. Now, nevertheless, I think that most of us, the majority of us who have heard the presentations today, feel that something has to be done. And when I contacted our panelists before this seminar and said what the discussion would be about, I suggested that we would discuss whether and how we could bring about a satisfactory reconciliation of the two areas. But now, after having heard Alan Bogg, I realize I shouldn't use the word reconcile, but instead I will rephrase it and ask what should be done, and what is possible, what is politically possible, what is legally possible, and what do you think? What should we do? And I first give the word to Petra.
Thank you very much, Kerstin, and thank you very much, Samuel, and the Oxford team for inviting me to this panel. Oh, sorry. Thank you. So now I'm back again. And to give you some brief comments on this very easy question to deal with. But at least I will, I'm a cautious person, so I think the suggestions I will formulate here today and are a bit, correspond to my cautious personality. I don't think it's really possible in the near future to overcome in total the conflict between economic freedoms and some national labor law systems right now. But I think there are three possible roads which we could try to, which could move forward the social dimension in this conflict. And I think that the Finnish case, which we just talked about, shows us one possibility, and that is, of course, to elevate the ceiling and to widen the walls in Article 3 in the Posting of Workers Directive. And I think that is a very important road forward, which we really should try to work out as much as possible from. And the second thing is to limit the scope of the Posting of Workers Directive. And I think there are already here today many interesting suggestions have been put forward. One is, of course, to fight the bogus self-employment, and in that case argue that that is, of course, outside the concept of posting. But there are other roads forward which I think could be valuable to try. And that is the temporary dimension of the Posting of Workers Directive. I mean, it's a temporary provision of services which should be covered by the concept of posted workers. And many of these service provisions, they last for a very long time. In Sweden, we've been discussing these infrastructure projects, for example, which have been occurring for ages, for many, many years. And is it really reasonable to argue that different labor law rights should be provided for those workers who work in a particular work site for a very long time, and a national workforce. So what is temporary from this perspective? And a third step forward would be to actually use the new case law on human rights issues, the stronger protection which has been clearly formulated both the European Court of Human Rights and the Supreme Court in Canada, and also from the ILO bodies and the Committee of Social Rights, in order to take back what the European Court of Justice took away from us, the margin of appreciation. As it gave in Schmidberg or in Omega. I think the argument is that the margin of appreciation is extremely important here, and therefore it gives less room for the European Court of Justice to inflict on national labor law systems and national collective labor law systems in their way of applying the right to strike. So that's what I would like to say now to start with. Thank you.
Yeah. There are many opinions one could have about the development of EU law. However, first of all, it has truly opened up Europe. The EU rules of free movement has been truly important both for individual and companies when they wish to sell goods. On the other side, which is most certainly true for the Posted Workers Directive, the impact on domestic law has not always been what many expected it would be. And the issue today, as we have heard in the many well-written and much-needed comparative reports in the area, is that the impact on domestic law has had a very different effects, both positive and negative, depending on the labor law system. These comparative reports are much needed, as there seems to be maybe a lack of understanding or maybe a lack of knowledge on how different national labor law system works, seeing the outcome of these judgments. But if we go further to the question that we were talking about today, whether or not we call it reconciling internal market law with European and domestic law or something else, the answer might depending on which country you ask. We could leave it, there are several ways to do this. We could leave it to the court to further develop the law. We have seen two recent judgments which is quite positive for us in this area. We could propose treaty changes in order to strengthen fundamental rights. Both of these solutions, however, are unpredictable, and at least for treaty changes, will take a very long time. But however, I also think that member states should become better to use the national room for maneuver or margin of appreciation. And one good example of this is the Posting of Workers Enforcement Directive. I take part as a representative for TCO in a governmental public committee which deals with this, with the enforcement of this directive. And we think that this directive can solve many of the problems we as trade unions have seen, such as abuse of the Posting of Workers Directive, by better defining what a posted worker is, and also to make it easier for those who are truly posted workers to enforce their right. So yeah, one way for member states to better take use of the measures that we actually have. So.
Thank you, Sofia.
Yes, thank you for inviting me. First of all, I should say that this book is in many ways unique. We have never had this type of studies before, where you actually follow up how European law affects national law in all the member states and the new cases and so on. So that is certainly a very valuable contribution. Then VikingLaval, well, I must say my personal view about Laval, first of all, is that that case should never have been brought to the European Court of Justice. It should have been settled. It was the wrong case. There was a kind of flavor of protectionism about that case, which and it comes to my mind, old saying, hard cases make bad law. And I think it is a bit unhappy that Laval has got all that attention. Then going directly to your questions, first of all, it should be stressed that Article 28 in the Charter of Fundamental Rights of the European Union clearly states that the right to strike and other collective actions are parts of fundamental rights. But as was emphasized before here, there is a balancing kind of assessment in the EU court, where using some kind of proportionality test, you can balance different rights, which are right to establish, right to establishment, right to services, free movement, etc. On the other hand, and the freedom to strike and other freedom to other collective actions on the other side. And in my opinion, much can be done in the direction which is advised by Steve Weatherhill in this book, namely to bring into this balancing more social market considerations. And here has been mentioned the ILO law and the European Social Charter and so on. Well, they should both be tools of interpretation. I mean, the EU law is wide open, really. There are very broad principles. And how do you really get the more detailed norms when you should do the balancing? Well, use the other instruments, take them into regard. And that will be my way of suggesting a solution within the ambit of the present legislation.
Okay, thank you.
Thank you. So I'll have the opportunity shortly in my concluding remarks to engage in a bit of general theorizing and try and draw some general conclusions from this morning's discussions. But faithfully to what we've been asked by Kirsten to do in this panel, I'll therefore just concentrate for a moment on the recent case law, and in particular the Kunston case, C41313, which, as we've been told earlier this morning, looks at one of the issues flowing out of, in a sense, the great VikingLaval debate, namely the, as it were, personal scope of EU labour law, labour or employment law, and the boundary, therefore, if you like, in terms of personal work relations between, on the one hand, EU labour and employment law, picking up on national labour and employment law, and on the other hand, the EU law of economic freedoms and EU competition law. And as has been explained by earlier speakers, the Kunston case, in effect, pushes out the boundary of EU labour or employment law towards the inclusion of certain categories, at least, of self-employed persons, the category I like to think of as personally self-employed workers. Now, when you look at this problem of inclusion or exclusion of personally self-employed workers, it seems to me that it's like those looking at those pictures often described as optical illusions, in which you're gazing at a presentation of a pattern of cubes, or you might be looking at a face mask. And the problem is whether what you're looking at is protruding towards you or receding away from you. And we could think in that way about the problem of allocation to legal spaces of the personally self-employed workers. Should the application of labour laws and collective bargaining structures to personally self-employed workers be regarded as a natural and self-evident application of labour and employment laws, in which case labour and employment law is, to use my metaphor, naturally protruding towards us? Or is it, on the other hand, an intrusion, a protrusion into that sphere from the general EU law of economic freedoms and competition law? In which case, that extension to self-employed, personally self-employed workers of labour law norms in the widest sense is going to be seen as of an essentially dubious extension of questionable legitimacy. I myself argue that in the form in which the Court of Justice of the European Union has maintained the effective scope of labour law, that it is the former perspective which is the more true one, that this is a natural and self-evident and legitimate projection of the scope of EU labour law, and this is part of a larger theory which I will seek to develop or revert to in my concluding remarks. Thank you.
Thank you very much. Is there anyone who feels wants to answer immediately to anything that is said? Yes?
Well, just a few words to what you said, Mark. I think the EU law has developed a lot and is developing. We have much more now of what you could call a social Europe, and it is included in the treaty nowadays that there should be a social market economy. I mean, as I said, the Charter has a social chapter. One of the provisions is on the right to strike and so on. So I think we should look upon the EU as a still developing project, which is not to the same extent as the case before, concentrated on the four freedoms and competition, but has a much larger scope.
Yes, but I would also say that I think it's important in relation to what you just said, that it's very important to distinguish, to help the court in that way, in order to distinguish the cases, in order to find new ways forward. To what extent is the case we are giving the national courts has a huge responsibility here in trying to explain how the question they are referring to the European Court of Justice in this case can be distinguished from the previous case law in order to help the court to develop new roads forward. I think we have as being a teacher, I think we have a very important pedagogical task here. The judges have that too. Thank you.
I think that this, for example, this Dutch case could be maybe a new way forward from the court, since I mean, we have changing labor markets in Europe, and this might be an answer that there is one group that is not very well protected. And for this example, these false self-employed, as they call them, And the court actually takes this into consideration and tries to protect them, even though it's a different type of employment. So to say.
I too was when I read both when I read this Kunsten and this sähköalojen ammattiliitto. That's how it's pronounced. I was so optimistic because I thought, oh, is it in fact so that the court is beginning to sober up or something, or is it just that you have so low expectations these days that you're glad every day you won't get hit by the court? But I hear from you that you see a positive development here. Perhaps it's something that you could that we could hope for. Another issue that the time flies actually. Another question I would like to raise with you is that many have hoped that things would change as soon as the EU exceeds the European Charter Convention of Human Rights. And Alan Bogg was, as I understood you, positive here. As I read the contribution in this book by there was another name which I'm not sure I can pronounce. Her name was Vilja Velvyte. She seems to be a bit hesitant, a bit doubtful whether it will, in fact, if it happens and when, if it will mean any great difference. What do you think of that? Petra, for example?
Well, thank you. Well, a few years ago, I was also quite skeptical with taking into account the Bosphorus case. I'm sorry, got a bad memory. I'm very sorry. Taking into account the Bosphorus case, where there was some kind of presumption from the European Court of Human Rights that.
You haven't turned it on, but leave it on, please.
Okay. Yes, a few years ago I was quite skeptical about what an accession could lead to, taking into account the Bosphorus case, where the European Court of Human Rights were very clear that there is some kind of presumption that EU law is already fulfilling the demands in relation to human rights standards according to the European Convention of Human Rights. But now I think it's quite interesting to see the new what is it called? Opinion from the European Court of Human Rights, when they so clearly, the European Court of EU, when they so clearly say that they want to stay in control of EU law, that could maybe, in correspondence with the previous other developments as we've been talking about in relation to, for example, the right to strike, can be ready to show the European Court of the EU, the European Court of Human Rights, that there are tensions here, and that a particular case could lead to a different outcome in the European Court of Human Rights. So, but I'm not sure about that, but that they might be a bit provoked, or it could be the other way around, that, okay, now we have to lay really still here in order not to provoke the European Court of Justice even further, so that there never will be an accession. So, sorry.
Well, I basically hold the same view. I mean,
it's your.
It
Okay.
was on, yes. The EU court practically slammed the door, had so harsh criticism against accession on present terms, at least, that it will take number of years, perhaps it will never happen, that there will be an accession of the European Union as such to the European Convention of Human Rights. But the basic question is really, does that matter so much for what we are talking about here? Because I don't think the jurisprudence in Strasbourg is that much helpful, really. It's, the EU law has such a broader scope that I think this has to be solved within the EU law, really, these problems.
Okay, thank you. Sofia?
Someone spoke earlier about a legal elephant in the room. And I think one good thing with this opinion that has come from the European Court of Justice on this matter is that it has clearly defined the tensions that we have in this matter, and that's one positive thing at least.
Do you want to comment on this?
I'll pass.
You pass. Okay. So I'll ask our host here. It's 12:30. Should we finish this debate, or should we? If there is anyone who has anything more to say.
Yeah, maybe we can take one or two questions.
Yes.
Yeah.
I don't know where the microphone is.
Let's hear it.
No. So, is there a question from the floor? A comment or a question? Yeah, Nicola.
My question is from Professor Friedland on the Dutch case on the false self-employed, and I mean, my fear is that that case missed an important opportunity. The important opportunity being, we don't care whether they are self-employed or false self-employed or really employees. But there is a fundamental right to collective bargaining that should apply regardless of status. And I can see a number of workers whose situation is improving as this case is being decided. But I can also see a number of workers, and I think your idea of that optical illusion here becomes very vivid to me. For instance, journalists that may be working under self-employed arrangements with one and a half journals or employers whose position will not improve. And there's also the point of principle as to whether, these rights. So, of course, I don't want to overstretch it, but that's my question.
You can see the full extent of my ineptitude in the face of IT provision of all kinds. My colleagues in Oxford, if not in the UK at large, will know that I spend a large part of my intellectual life engaged precisely in this discussion about where personal scope, where the personal scope boundary or boundaries should be placed. I very much agree, Nicola, with your suggestion that Kunsten is an essentially compromised decision. And I noticed in one or two blog postings that I've been reading about it, that in a number of national jurisdictions, they are concerned about the incompleteness of the extension of freedom of association rights to self-employed workers, which this decision represents. Nevertheless, I think I would say that in its way, the drawing of this boundary is almost as fraught a problem and a deeply current and urgent problem, almost as fraught in its way as Viking and Laval itself. And I don't think you're going to get any quick general worker protective outcome anytime soon. I therefore greatly welcome this advance, and from my normative perspective, which I know is a highly contested one, I hope that it will be followed by further advances in the same direction.
Thank you. Alan Bog.
Yeah, and just Just to follow on from Nicola's comment, so I mean, I think a kind of ILO point that can be made is that with respect to freedom of association, regarded as a fundamental human right, the committees have taken the view that self-employed persons should be within the scope of the right.
Yeah.
So I mean, I strongly support your normative claim, but there is some positive international law that supports the normative claim.
Yeah.
And I think the normative claim must be right. I mean, it comes back to what I said earlier. To describe it as a fundamental human right, if that's to be something other than a slogan, one of the normative consequences that follows from that is it's a right that inheres in humanity, not in a particular form of contractual relation.
Yeah.
So I think that's the first point. The second point is really just to sound a cautionary note about the emphasis on subordination in that case. Because in the English context, we've seen case law on the concept of worker. Now, worker is a legal category that is supposedly broader than the narrow category of employee. But what the United Kingdom Supreme Court has done in a case called Givrage is to apply a subordination test to the concept of worker, and the effect of that in subsequent case law has been to contract the personal boundary back towards employee. So it's had a restricting effect, and I think that would worry me about that decision and the emphasis on subordination as a technique.
Yeah, thank you. Yes. Yes.
Thank you. Okay. Now our time is at an end. So, well, that sounded a bit, well, we're not dying. But we should finish this discussion and leave the word to Mark Freeland for some concluding remarks. Please.
Thank you very much, Kirsten, and thank you to the panel.